Welcome to another episode of YouTube Audio Background Studying. In this particular episode, we're going to be delving into a treatise on the law of torts for those who are looking to understand tort law. And specifically, we're starting off with Chapter 1, the nature of tort. Tort is the French equivalent of the English word wrong and of Roman délit. This term was introduced in English law by the Norman jurists and is used at the present day to denote a civil wrong for which compensation in damages is recoverable, in contradistinction to a crime or misdemeanor, which is punished by the criminal law in the interests of society at large. Every invasion of a legal right, such as the right of property, or the rights incident to the possession of property, or the right of personal security, constitutes a tort. And so does every neglect of a legal duty, and every injury to the person or character or reputation of another. Sir Frederick Pollock says, quote, "It is hardly possible to frame a definition of a tort that will satisfy all the meanings in which the term has been used by persons and in documents of more or less authority in our law, and will at the same time not be wider than any of the authorities warrant." End quote. Dr. Underhill also remarks that no one has yet succeeded in formulating a perfectly satisfactory definition of a tort. Indeed, it may be doubted whether a scientific definition, which would at the same time convey any notion of the mind of the student, is possible. Pollock, in his voluminous treatise of the law of torts, gives the most complete definition of it. He thus sums up the normal idea of tort. Tort is an act or omission, not being merely the breach of a duty arising out of a personal relation or undertaken by contract, which is related to harm suffered by a determinate person in one of the following ways. A. It may be an act which, without lawful justification or excuse, is intended by the agent to cause harm, and does cause harm complained of. B. It may be an act in itself contrary to law, or an omission of specific legal duty, which causes harm not intended by the person so acting or omitting. C. It may be an act or omission causing harm which the person so acting or omitting did not intend to cause, but might and should with due diligence have foreseen and prevented. D. It may, in special cases, consist merely in not avoiding or preventing harm which the party was bound, absolutely or within limits, to avoid or prevent. End quote. Addison defines tort as the, quote, "the infringement without legal excuse of a right vested in some determinate person, either personally or as a member of the community, and available against the world at large, or against some person or body exercising public functions as such, whereby damage is caused to such determinate person, either intentionally or as a natural consequence of the infringement." End quote. Underhill defines it as, quote, "an act or omission which, independent of contract, is unauthorized by law, and results either in the infringement of some absolute right to which another is entitled, or in the infliction upon him of some substantial loss of money, health, or material comfort, beyond that suffered by the rest of the public, and which infringement or infliction of loss is remedial by an action for damages, end quote. A tort, remarks Innes, is usually said to be, quote, a wrong independent of contract. For example, the violation of an independent of contract. And it will be seen by the statement that the rights of which a tort is a violation are, in fact, distinct from those arising out of contract. But they are also, as will be seen, distinct from a vast array of other rights, so that the usual definition is as defective as would be a definition of the horse as a class of animal independent of horned cattle. He then gives the following as a more accurate definition, quote, a tort is the unauthorized prejudicial interference of some person by act or omission with a right in rem of another person. The conduct which brings about the prejudicial interference is said to be tortious, end quote. Broom says, quote, a tort is a wrongful act involving the idea, if not of some infraction of law, at all events of some infringement or withholding of a legal right, or some violation of a legal right, end quote. According to Collette, tort means that which is wrested or crooked, and so that which is contrary to right. A tort has been usually described as a wrong independent of contract. As such, a tort may be described as an invasion by A of B's right, which avail against persons generally, in respect of either property, person, liberty, or reputation, end quote. In Alexander's Indian case law on torts, the following definition is given. Quote, a tort may be defined to be a combination of two ingredients. A legally wrongful act or omission on the part of one person causing B damage in legally contemplation of another person, end quote. Sir William Markby, without attempting to define the term, observes that the act or omission, which is said to be an injury, is qualified by some adverb which is apparently intended to indicate that which constitutes the required test of liability. Such adverbs are 1. Fraudulently, dishonestly, maliciously, knowingly, intentionally, wantonly, malignantly, rationally, negligently, willfully, wickedly, imprudently, clumsily. 2. Forcibly, violently, riotously, tumultuously. 3. Wrongly, feloniously, unlawfully, illegally, injuriously, and unjustly. The adverbs in 1 express the condition of mind of the person who does the act. Those in 2 express what is commonly called an aggravation. That is to say, to mark the act as giving rise to a special secondary or sanctioning obligation of a serious kind. Those in 3 express something, but really express nothing at law, being only so many different names for the very thing the nature of which we are trying to discover. An English statute defines tort as, quote, a wrong independent of contract, end quote. But there are many torts in some way connected with contracts and said to arise out of or flow from contracts. See Innes' remarks above. The Judicial Committee has, in a leading case, defined tort as, quote, an act or omission which prejudicially affects another in some legal right, end quote, citing Rogers versus Redondo Data. The law of torts, constituting as it does a portion of the law of obligations, comprises a class of violations of the right in rem of one person by another. By example, by that other's instrumentality. The instrumentality may be that other's own immediate conduct, or it may consist of his conduct acting through that of other responsible instruments, as for instance, agents, or through irresponsible and perhaps inanimate instruments, as dangerous animals and things. In a large proportion of injuries, the harm is inflicted upon others by the direct instrumentality of the person answerable. In another large proportion, through personal agents upon third parties. But it is sometimes happens that the harm directly follows some course of action of the injured person himself, into which he has been betrayed by the conduct of the person answerable, entered upon or pursued with the intention that the injured person should act in a particular way with reference to such conduct, or of such nature that though there was no actual intention, the conduct was calculated or liable to induce the injured person to act upon it. Inus. The law of contracts is a development of the semi-ethical precept, quote, thou shalt do no harm to thy neighbor, end quote, and the maxim ubi jus ubi remedium, meaning there is no wrong without a remedy. Tort and crime. The distinctions between a crime and a tort or civil injury are: 1. Torts are an infringement or privation of the private or civil rights belonging to individuals considered as individuals, whereas crimes are a breach of public rights and duties which affect the whole community considered as a community. Blackstone, Broom. 2. In tort, the wrongdoer has to compensate the injured party, whereas in crime, he is punished by the state. 3. In tort, the action is brought by the injured party. In crime, proceedings are conducted in the name of the sovereign. Austin. The same set of circumstances will, in fact, from one point of view constitute a tort, while from another point of view they will constitute an amount to a crime. In the case, for instance, of an assault, the right violated is that which every man has, that his bodily safety shall be respected. And for the wrong done to this right, the sufferer is entitled to get damages. But this is not all. The act of violence is a menace to the safety of society generally, and will therefore be punished by the state. So a libel is said to violate not only the right of an individual not to be defamed, but also the right of the state that no incentive shall be given to a breach of the peace. Holland. Where the same wrong is both a crime and a tort, its two aspects are not therefore identical. Its definition as a crime and as a tort may differ. What is a defense to the tort, as in libel to truth, may not be so in the crime, and the object and result of a prosecution of an action are different. Collette. Tort and contract. A tort may also be distinguished from a pure breach of contract. When there is an express promise and a legal obligation results from it, the action for a breach will be found on contract, whilst actions of tort arise from liabilities which originate in wrongs independent of contract and are either an infringement of a legal right or the violation of a legal duty. Chitty.